thank you all for joining this morning's session. For those of you who don't know me, I'm Jane Hussey. I'm a partner here at Mills & Reeve, and I lead our in-house in focus programme. Today I'm delighted that we're joined by Carol Westrop and Stephen Nelson from the Solicitors Regulatory Authority. Carol and Stephen are going to talk to us about the professional standards as they apply in particular to lawyers working in-house. So the way we will run this is that Carol and Stephen will speak for 30 minutes or so, and then there will be 10 minutes for them to answer questions. The way to raise a question is if you hover at the bottom of your screen, you will see the Q&A function. The only people who can see the question that you are asking are the panelists. And if you wish to remain anonymous from us with your question, then all you need to do is change your question setting to anonymous. And I'm raising this just in case anybody has something that they feel is a little bit sensitive. And equally, if you have questions that you would like to raise elsewhere, then perhaps the thing to do is to mail me or include it in the feedback form, which we will circulate a link to at the end of the session. In terms of housekeeping, we will be recording this morning's session and we will be circulating a link to you after the session. And the final point to make, and I will raise this again at the end, is how much we value your feedback, both in terms of the value you get from this session, but also in terms of other topics that you would like to cover in the future. So without spending any more time on housekeeping, I will hand over to Carol and Stephen.
Thank you, Jane, and thank you for the team at Mills & Reeve for inviting us to talk to you virtually today. As Jane says, my name is Carol Westrop and I'm Head of Legal Policy at the SRA, together with my colleague Stephen, who will join us for the Q&As later. We, like you, are in-house solicitors working for a regulator in our case. And I'm going to talk to you about the Standards and Regulations, which we introduced in November 2019, with a particular emphasis on how they apply to in-house solicitors. And then if we've got time, there's a couple of other things that I will just mention about the SRA's work. And as Jane has covered, we're very happy to answer questions on the Standards and Regulations or on any other issues that you might like to raise with us, and we'll certainly do our best to try to answer your questions. So on to the next slide, please. Kate, we're going to talk to you, as I say, about the principles and codes in detail, but just a little bit of positioning. And this is particularly why we're very pleased to have the opportunity to speak to our in-house community. It is we regulate over 190,000 solicitors, of which 31,000 or so work in-house. So a very important constituent of the individuals that we regulate, well over a quarter of those individuals that we regulate. As well, of course, about 10,500 law firms and about 700 alternative business structures, which I'm sure, as you know, are the vehicles by which external non-lawyers can own law firms in England and Wales. Now, I understand from Jane that you're from a range of different sectors. I think Jane described her as sector agnostic, so there'll be hopefully those from local government, industry, charities and the not-for-profit sector, as well as, like Stephen and I, possibly solicitors working for other regulators. So that's the broad context about what we regulate. On to the next slide, please, on what we do. Again, hopefully this is all very self-evident and well known to you. We have powers under a complex patchwork of different statutory provisions to regulate the legal profession, solicitors in England and Wales, in the public interest. And that's on the slide is essentially what we do, regulating the public interest We set the standards for entry. I haven't got the time, unfortunately, to go into our new solicitors qualifying examination, due to come into effect in sort of autumn 2021. But that's obviously a main plank of our work in relation to that issue. We license both individual and firms to practice. We set high standards through our policy work and our standards and rules, and we take action when things go wrong to make sure those high standards are met. We also, for example, operate a compensation fund, which will provide redress to clients who suffered loss through the dishonesty or failure to account by a solicitor. And when we do that, we have to have regard to the regulatory objectives set out in the Legal Services Act, and that says what we and the other legal services regulators have to do in terms of the objectives, all around promoting the public interest, making sure that the rule of law and the proper administration of justice is maintained, improving access to justice, a very interesting objective, and encouraging an independent, strong, diverse and effective legal profession. So we have to regulate with regard to the regulatory objectives, and that informs many of the areas of work and the approaches that we adopt. So moving on to the slides, in particular to our handbook reforms and our standards and regulations, and how we've reached where we are now in 2020. Just a little bit of background. So we have done a root and branch reform of what was our 2011 handbook over the last number of years. Lots of consultations and engagements, and hopefully all of you may have been involved or at least aware of this. The handbook in 2011 was quite a lengthy document, around 600 pages, very hard to navigate around. So particularly for in-house solicitors, we used the provisions that apply to in-house as a bolt-on to the various rules and regulations and codes. So it was quite difficult to find out, if you're in-house, what rules actually applied to you and your practice. More broadly, we felt that our approach engendered a kind of restrictive approach to practice. You know, people would only generally do what they thought they could do, but wouldn't embrace the flexibility that was inherent in the legislative framework, and a bit of a tick box compliance culture. So you would tick a box to say you've done that without sometimes applying your professional judgment to the issue and making a reasoned decision on the facts. And we should say that as professionals, we clearly rely on you and the extensive training that you've undertaken to exercise that professional judgment properly. And of course, in the vast majority of cases, that's exactly what happens. So we wanted to address what we perceive to be the problems with an unwieldy, lengthy and quite complex set of rules into a new set of rules. Much sharper focus on ethical behaviour and high standards, making it shorter and more user-friendly to all types of practice, so including in-house as well as those who practice in authorised firms, and giving solicitors some more freedoms about how they practice, to deal with some of our objectives around improving access to legal services and making sure that consumers have choice and the ability to get legal services if required. Obviously, that's really important. So the next slide is just a very brief overview of some of the main areas now captured in the standards and regulations, introduced on the 25th of November. So we're now sort of getting on for 10, 11 months into their operation. I should say that we have committed to do a 1, 3 and 5 year review of how they're bedding down. Are there any issues or areas that we need to address? So we are coming to the first anniversary of that quite soon. But what's in the standard regulations? Well, there's revised principles and codes of conduct, particularly for individuals and firms. I'm going to concentrate on the code for individuals, as that will be most relevant to this audience. Simplified accounts rules. I'm not going to touch on the accounts rules because generally you won't hold client money, but obviously you need to be aware, particularly if you're doing transactional work with law firms, that there are rules about the holding of client money and the need to keep it safe and separate from the firm's own money. I will talk about the new practising flexibility, and I will talk briefly about the enforcement strategy. So that's the suite of rules. They are all obviously published on our website and underpinned by other rules around authorisation of individuals, authorisation of firms, character and suitability issues when you enter the profession, and so on. But the one main ones of interest to you, I think, are going to be the principles of the codes and so on. So I'll spend most of my time talking about those. The principles, this is an overview because we will drill down into the principles as they apply to in-house practice in a little bit more detail in a moment. But the principles are on the slide in front of you. There used to be 10, there's now 7. We have split in honesty and integrity. That used to be a combined principle, but that reflects developments in case law where it has become clear that there is a separate standard and a separate test, and they're not synonymous. Integrity is a broader context. So the ones that are particularly relevant to you: independence, integrity, best interest of your clients, upholding public trust and confidence, and obviously the administration of justice. So in effect, lots of those principles bite on in-house practice. One interesting issue, which I will just talk about briefly, is how those principles apply to private life. The principles, I should say, apply to both individual solicitors, firms, and employees of law firms. So they're pervading ethical principles we expect all those that we regulate to comply with. There's been an interesting debate recently about, well, not even recently, for some time, about how much we should regulate someone's private life, so conduct outside of practice. The principles do apply outside of practice as the context requires. And there's been a recent quite interesting debate about where the line should be drawn, to a large extent driven by societal developments, in particular the Me Too movement and allegations of sexual harassment, and whether we should be looking at those issues as a regulator, and also driven by social media, and should we regulate what someone does on Twitter or Facebook. Just so that you know our position, it is set out in our enforcement strategy, and I'll talk about that later, but generally we are here to regulate practice. We are the regulator of solicitors in England and Wales and their law firms. But we will take action on a case-by-case basis. If we think that either someone has a criminal conviction or caution, we will always investigate those. Or if we think the actions in a private life might affect public confidence in the delivery of effective legal services, or it might impact the way that that person might then operate or conduct themselves in their professional lives. So we do take an interest on conduct in private life, but there generally has to be a connection with someone's professional life. So those are the principles. Then moving on to the next slide, the codes of conduct. As I say, we have a code for firms, which I won't talk about, which sets out more kind of business processes and systems which firms are required to comply with. The code for individuals is where you'd want to look now as in-house solicitors to make sure that you understand the standards that apply to you. So alongside the principles, the code for individual now sets out in more detail the rules that apply to you in your in-house practice. Again, as I said, we think it's an important improvement for in-house lawyers, because it's much easier for in-house lawyers like Stephen and I to find the sets of rules that apply to us. And I think there used to be a misconception in-house that sometimes the rules didn't apply to those who worked in-house, and for law firms that sometimes its compliance is an issue for the in-house compliance team or the managers or the partners, and not all the individual solicitors that work in those firms. So I think it's easier to understand the requirements that apply. It's written to be more generally applicable to in-house, so we've nuanced the references to client care and more about when you deliver services to members of the public. We've got rid of the indicative behaviours, which those of you who will remember the handbook set out some examples of how we felt you could meet the standards we require. But I think sometimes people thought they're actually more like detailed rules and were slightly confused about their status. So we've removed those. But we have updated all of our existing guidance to make sure that it reflects the rules in the new standards and regulations. And we are developing and have been developing some more guidance on some of the grayer areas, which is to help you really decide how to exercise your professional judgment. So putting matters when things go wrong for clients, conflicts of interests, and reporting concerns. And I'm going to talk about reporting concerns to us in a little while. So moving on to the next slide, I will just touch very briefly on our transparency rules. Again, they generally apply to law firms that we regulate, but I think it's generally hopefully interesting to be reminded that they exist and to understand the drivers for them. Lots of press coverage about the Competition and Markets Authority review into the way consumers access legal services. Law firms are very and have been very bad and behind the curve about publishing price and service information compared with many other sectors of the economy. In 2018, for example, only 18% of solicitors' firms published price information. And there's been a big driver to make sure that consumers can access information to help them make informed choices. And we've been doing a lot of work in this space. So we now require law firms to, on the more commoditized sort of areas where people regularly purchase legal services, matrimonial, conveyancing, road traffic accidents, both for small businesses and for individuals, to have some price information and how to complain if things go wrong. And firms also are required to display the SRA's clickable logo, which basically confirms that the firm is properly regulated and authorised by us and sets out the protections that regulation brings with it, insurance, compensation fund, and so on. And it might be useful for you to be able to verify a firm that you're dealing with is properly regulated, particularly in the high instances of cybercrime that we currently are facing. Probably more relevant to you is the register that we have on solicitors and firms and individuals. If you click on to the next slide, you'll just see an example of Stephen's entry into the solicitors register, which if you haven't looked, you can search against your name and the firm. Very, very, hopefully quite easy to search against. So Stephen's entry talks the date of his admission, whether he's got a practice certificate, his ID number, who regulates him, and also whether he has any disciplinary or regulatory history. Very pleased to see that in this case he hasn't. If a solicitor has been prohibited from practice by being struck off or controlled, that information is displayed on the register. So useful for you if you want to validate an individual or a firm that you might be doing transactional work. The Solicitors Register is now an important tool on our website. That was also launched in November, and we are continuing to enhance it as we move forward. The next slide, please, is just to talk briefly about practicing flexibility. Again, this was quite a hotly contested area of our reforms, and whether or not we should allow solicitors to practice outside of authorised firms and retain the title solicitor. And we had a number of consultations on that issue and some quite hotly held views. We introduced the changes in November along with the rest of the standards and regulations, and there were two main things just to bear in mind. One is that solicitors can now offer reserved legal work to the public as freelancers. This is set out in Rule 10 of our authorisation of individual rules. There are obviously some controls, some conditions that need to be met before a solicitor can do this. They have to have, for example, 3 years experience. They have to have adequate indemnity insurance. They have to make it clear to their clients the context in which they're acting, and they must be true freelancers. So, they can't have employees or partners. They're really just engaging with an individual to provide legal work. But we are seeing a steady but increasing take-up of that ability, and it's attractive to some people who may have recently retired or want to work part-time but be able to do some reserved work to clients. We also have allowed solicitors to offer non-reserved legal work to the public in unregulated organisations. So you could be a solicitor working in a will writing firm or or giving employment advice that is a regulated legal activity, but you can still call yourself a solicitor. You would be subject to our regulation, obviously, in terms of compliance with the codes of conduct and the principles, but you can offer your services in a more flexible way. And again, hopefully this will ensure that consumers have better access to well-regulated, professional, high ethical legal services from the solicitors that we regulate. Moving on to the next slide then. Working in-house and how the standards and regulations apply to those of you and myself who work in-house. A few general thoughts really. Working in-house, I think we all appreciate, come with different considerations as to both conduct and risk. And perhaps sometimes without the same level of support that some of us who have worked in large firms might expect to receive from fantastic compliance teams and other support mechanisms. And it's the balancing act between managing the legal risk within your employer whilst making sure that you do meet your professional obligations as a regulated individual. So alongside of making sure that you meet the professional regulations in our standards, you may also need, of course, to meet any other regulatory oversight that your employer might be subject to. So, for example, regulation by the Financial Conduct Authority, by reporting obligations to Treasury or to Parliament. Those will generally be for your employer to manage, but you might well be called to advise upon those issues. When doing so, you obviously have to comply with your own professional obligations in our standards and regulations. So the ethical concepts governing a solicitor's role and behaviour, as expressed by both us and case law, of course there's a big body of case law about these issues, apply equally to you, with obligation to protect your independence, promote the best interests of your clients, uphold the rule of law and the proper administration of justice. But there's been a recognition of some of the unique pressures which in-house solicitors might face, which might lead to risks of them compromising their ethical behaviour. And we're going to talk about some of those now. So I'm going to pick up a few of the key areas. Independence is obviously a key issue. Independence where you only have one client and that client is your employer. And it's really around the ability to say no or push back if you think a course of action would compromise your own regulatory responsibilities. But appreciating that this is a balancing role with the company because there may be obligations to the board or to shareholders. We have limited practical examples of how this works within the SRA. We get very few, and I'll talk about this a little bit later, complaints or reports from in-house firms. So we don't have a body of a great body on which to draw on. It's an issue very much being chewed over by academics. Professor Moorhead has recently, you may have seen this, had a suggestion that there be some rules, guidelines that guide in-house solicitors, really more for the board and the executive directors to understand the position of in-house solicitors and some of the pressures that they face. And they've drawn up some quite detailed guidelines to help inform that debate, and that's had some traction in the legal press, and certainly worth an interest and a look at if you're in that sphere. We've also thought about whether we should perhaps issue some more guidance on independence as well on the back of some of the recent academic literature, and again would be interested in your views about whether you think that would be helpful. Systems and controls, following on really from the independence, as I mentioned, there may be less systems and controls in in-house practice than there is in a law firm, where you might have a dedicated team dealing with ethical issues and standards and regulations. However, you should be aware that you have an obligation to make sure that you have the right systems and controls for your in-house practice, and particularly that you keep records of difficult decisions that you might have to make. That's common sense, but also important that you do so should your behaviour be second-guessed or you be subject to some sort of inquiry or investigation in the future. So keeping records of difficult decisions is something that we very much encourage. So looking at your systems and controls is important. Moving on to the next slide, one example of where that might come to bear is in relation to supervision. You may be working on your own, but you may have a small team of other lawyers that you manage or supervise in your in-house practice. The codes, and these apply to you, require you to effectively supervise or manage the work done by those individuals, and also to ensure that your team is competent. There's rules 3.5 and 3.6 of our code for individuals, provide that you need to make sure that you have effective supervision and that the people that you manage are competent to carry out the work that you give to them, and also that they understand their legal, ethical and regulatory obligations and keep up to date with those. And this is why we're very pleased to be able to come and talk to you about kind of the ethical obligations and the regulatory obligations to in-house teams. So you'll need to ensure that you have systems to make sure that you function properly as an in-house team in terms of providing services to your clients. Moving on to the next slide then, this issue about who is your client. So your employer and other persons or groups within the organisation will generally be regarded by you as an in-house lawyer as your client, and you'll be providing services to them. That's replicated in our codes, which says the client's the person for whom you're acting. And it's always worth considering who you're acting for. Probably not so much of an issue if you've just got a quite straightforward structure where you have a single employee with a single kind of remit and role, but it may become more complex for larger group structures, and whether the virtual constituents of those are approaching things in the same way. So always worth considering who are your clients and what the impact of the matter is on that individual or entity. So moving on to the next slide, client's best interests. You must act in the best interest of your client or your clients, but clearly you have to balance that with your public interest considerations as set out in the principles, particularly administration of justice, the rule of law, which are obviously very significant and important duties on us all. So our principles has a little bit of introduction which makes that very clear, that should the principles come into conflict, those which will safeguard the wider public interest, such as the rule of law, public confidence in a trustworthy solicitor's profession and a safe and effective market, take precedence over your client's sort of individual interests. So you should inform your clients of the circumstances where you might need to rely on duty to the court or your professional obligations, and when that might outweigh your obligations to act in their best interests. So this comes back to your ability to say no or push back, that notwithstanding what might be in your employer's best interest, that you have your own professional obligations and duties. A bit of a trite example on the slide, it's fairly obvious, but this does happen. You might be working on an action, you've missed a deadline by a day, a senior member of the organisation might just say, well, you can just backdate that document and, it's not today, but, backdated to a couple of days ago, there's no harm done. And everyone sort of nods, well, that seems very sensible. In those circumstances, your duty not to mislead the court, to act with integrity, to act with honesty, perhaps in those circumstances, are paramount, and therefore, you will need to push back in those circumstances. I think, as I mentioned, the Stephen Mason and Professor Moorhead reviews, and the thinking is to give in-house solicitors more ammunition to say, this is why I have to act in this way, because I have to have regard to these higher ethical principles. But it's important to remember that exists for you. And as I say, document issues where there are difficult decisions, probably important to keep an audit trail of your thinking. Conflicts of interest. So this equally applies to you. Rule 6.2, you mustn't act if there's a conflict of interest or a significant risk of a conflict. Probably won't apply that much, because generally applies where you're acting for two different clients in private practice, but it may arise in-house in a group context. So the example there, you're asked to act for a wholly owned subsidiary on a finance agreement to be guaranteed by the parent company. Potentially a risk of a conflict. There is an exception to the rule which says if your parties have a substantially common interest in the matter, then it's appropriate for you to act if it's reasonable. But the things happen, and sometimes there may be a disagreement between the directors of the two different constituents about what's acceptable, what's in their own entity's best interests, and if so, those duties may potentially come into conflict. So you need to be aware of the risk of conflicts when acting, and to make sure that you are satisfied that it's appropriate for you to act, and that you can give impartial, independent, unbiased advice to both parties. So those are the key things in relation to the principles and the codes that we thought we should highlight for in-house practice. Independence, always a key issue. Having correct systems and controls, and your duty to supervise and make sure your staff are competent. Make sure that you push back when needed, accepting that you obviously need to do a good job for your clients, but that's not at the higher cost of the other ethical principles. And if there are any conflicts, making sure you think about them and manage those in accordance with our rules. We've got guidance on these issues on our website around best interests and your duty to the courts, misleading the courts. Some other quite recent topical guidance that might be of interest to you, non-disclosure agreements and our warning notice about your role in advising those. That might well happen in-house for your employer. Sexual harassment issues can happen anywhere. Social media and drink driving, always a bit of an issue for us where we pitch ourselves. But guidance on these examples are on our website. The next slide then, I'm just going to talk about this briefly because I'm conscious of the time and want to make sure that we have some time for questions. Reporting concerns. Important that you realise that there is an obligation on you to report matters to us. We don't get very many reports from in-house solicitors, and there are very good reasons for that. You don't hold client money, you don't act for members of the public. But we do get some, and it's important that we do get them so that we can address any risks that person poses and to make sure public confidence is maintained. So important that you understand there are. The reporting matters of concerns, as the slide shows, we've done quite a lot of work around this to hopefully improve clarity for the profession and the public, and to set out when concerns should be reported. Essentially, we've moved to a test that rather than reporting serious issues, you need to report to us where you reasonably think, and that's an exercise of your judgment, there are facts and matters which could give rise to a finding of a serious breach of our principles. So we've detailed some guidance on this in reporting and notification. I think it's important that those of you who are in-house or manage a team read that guidance and think about the issues. We are clear that we will view very seriously any attempt to harass or subject anyone who's made a report to us to detriment. Important, we don't use the word whistleblowing, but anyone who speaks up and wants to raise things, obviously it's important that they do so. And our reporting concerns guidance talks about how we protect confidential information, how we deal with vulnerable individuals. So important, I think, that you appreciate that requirement to report matters to us, and have a look at the guidance that we published, and we can certainly circulate the links around later if that would be helpful. Our enforcement strategy underpins our approach to taking action. Again, I would suggest that you read it if you haven't already, because that sort of sets out our view of what's serious. Makes it clear we won't take action for trivial, one-off matters, mistakes, matters that don't engage our principles or our rules. If you're trying to do the right thing, that's fine. That's what we expect you to do, and our enforcement strategy won't be engaged. But it does set out when we will take action. We're always going to be concerned about criminal convictions and cautions, serious breaches of our principles that might involve abuse of trust, sexual or violent misconduct, acting in a dishonest way. We'll always want to know about that and take action. And we have powers and ability to access privileged material and so on, that if you were looking at a matter in-house, you might not be able to access. So if you haven't, I would commend you to read the reporting concerns guidance and the enforcement strategy as well, just so that you can understand really what the SRA's approach is. Very little enforcement against in-house lawyers. As I've said, very few reports, so limited examples. We have had some STT and other proceedings, normally around misleading the court or not making a proper disclosure with a view to misleading. Brings us back to that duty to act in your client's best interest and the perception that that has about keeping things back, but actually the higher public duties around administration of justice. So mercifully few, but important that obviously we do take action where we think it's necessary. Other regulatory updates, moving on. I'm just going to talk about a couple of things. Those are things that we're working on. Assuring advocacy standards. We've got quite a lot of work about how do we make sure that both civil and criminal advocates are competent. It's a difficult issue, but we're going to issue a consultation on that shortly. And leaving the EU. I don't know if we've got any RELs on the call working in-house, but we're doing a lot of work to make sure that we make the transition as smooth as possible when we do finally leave the EU after the implementation period on the 1st of January next year. The other things just to mention is we've got a corporate strategy, if anyone's interested, where we put our resource. I won't talk about that any further. Guidance and support, as I've said, ethics guidance helpline, very useful resource to any of you who are facing an ethical dilemma and in your practice and want to seek a view from our expert practitioners in this area. As I said, we've got a lot of guidance that might help support you, topic guides about how we enforce. And we do a lot of research and reports about risks in the legal services market, cybercrime, money laundering, a big topic for us at the moment. So, there's a lot of information on our website if you're interested in understanding the broader legal services landscape. The next slide just talks about the resources. So you've got that in your slide pack should you want to click through and find some resources as well. So that's the end of my presentation. I have rushed through the last bit slightly quickly because I'm conscious that you may well have some questions. And as I've said, if we can't answer them now, then we will do our best working with Jane and the team at Mills and Reeve, perhaps to get back to you separately on those. So over to you now, Jane, I think.
Thank you, Carol. And yes, we've been busy on the Q&A board. So and I suspect some of the questions may need a perhaps nuanced sort of thought process, which may be beyond the scope of timing now. But just very quickly, the first question is, can you give any guidance as to how the public is defined? because it's not defined in the LSA. So we'll be grateful for thoughts you've got on that.
I pick that up, Carol?
Yes, please. Thanks, Stephen.
Yeah, so there is some guidance on this on our website, which we could circulate after this webinar. This is in the context, I'm assuming, of the extent to which your organisation needs to be authorised where it's providing reserve legal services. As you pointed out in your question, Rod, the helpful element of the Legal Services Act is that it does not in any way define what it means by the public or a section of the public, which is why we've had to produce guidance on it. Our starting point is on this more to do with, are you providing services to your employer or a person connected to your employer? So if you are, and this usually includes holding, associated or subsidiary companies, employees, sometimes associations and clubs and the members, then it's highly likely you're not providing services to the public or a section of the public. It's when it goes beyond that that it can become complex, and it will depend very much on the specific relationship that your client has with the employer. Yeah, it very much depends. There isn't a clear defined position on this. It would be for the court to decide ultimately, but our guidance note does give you some indications of where we tend to fall on these matters, and also again our ethics team alongside our authorization team will be able to help if there's a specific issue you're looking at.
Thank you, Stephen. Another question that's come up is somebody describing their role in a global company as being for Europe, the Middle East and Africa. And of course, they are qualified to practice in England and Wales. So sort of asking for a little bit of guidance around the regulatory sort of censure risks that they need to be aware of in the context of the SRA standards and regulations.
I think my feeling is that it's a question I've never been asked before, but I don't think our regulatory arrangements would be engaged by that. It's a matter of how they describe themselves as, obviously, if there was any indication that they were authorised or recognised to practice in those jurisdictions when they weren't, there may be an issue. But if it's simply the way that someone wishes to describe themselves in terms of their role, I don't think that would engage our regulatory rules.
Okay, thank you, Carol. Another question that's come up, and I expect that lots of the attendees are in this position where they also manage non-legal functions. So a question's arisen as to how does this sort of apply, or does it apply in the context of those non-legal functions?
I suppose
no, I don't think it does. I mean, our remit. Sorry, Stephen. Go.
No, I was going to say the same that you're about to say, I'm assuming, which was, our remit is you supervising the legal services that are provided. So those within your team providing legal services to the client, they're the people you supervise from our perspective. And we're less, well, I don't think we would take any interest, particularly in supervision of others, unless I suppose a conduct issue arose in that in terms of the way you handle it, I guess. But I think that risk is very, very slim.
Okay.
Yeah, I think that comes back to the individual rules which the individual solicitor has to adhere to. A little bit of a parallel perhaps to private life. So if they've done something wrong in relation to that relationship, it may be an issue. But no, our remit is, as Stephen rightly says, is around the supervision and management of teams providing legal services and not. I'm surprised that hats off to the in-house solicitors who have to wear so many different hats and do so many different things, but that's not something that would engage, I say, our regulatory oversight, because we're very much around, I say, the legal services aspects of that.
Yeah, my experience from the in-house lawyers I know is that they tend to attract more and more functions to be responsible for.
I do recognise.
Okay, another question is an in-house counsel. If an in-house counsel were to be working for an employer organisation where there is a serious risk of insolvency, and the in-house counsel has advised the board against the risks of wrongful training, how should they deal with that? Which, again, I think is probably, sadly, quite relevant to our times.
Yeah, so I think so. I'll kick off in my view and see if Stephen's got anything to add. I mean, there is a specific obligation on solicitors in regulated law firms to report financial instability or potential insolvency by the law firm, but that doesn't extend to the obligation to report to us in relation to the employers if it's the sort of the entity, because we don't regulate the entity, we don't regulate the non law firm, the individual solicitors in there that we obviously regulate. Would we have an interest if they felt we obviously wouldn't have any regulatory reach over the entity in those circumstances, but I suppose there is an interesting issue if there were a potential compromise to kind of the thing that we regulate. I'm struggling to see why there might be and how that might interact. Stephen, can you think of any examples where that might be relevant to us?
I suppose the issue would be more if you're pressured by the board to sort of change your advice that, there's no risk of wrongful trading, or advise your business to continue trading wrongfully. And so long as you're going back to the point earlier about balancing the best interests of your client with your obligations of independence, etc., as long as you're comfortable giving the advice you need to be, and there is no regulatory point that says you have to step away from working for that organization, as long as you feel satisfied that you're giving the best advice you can in the circumstances and you keep that independence, and then it's for your professional judgment as to whether you could continue in that circumstance if the board are refusing to listen to you. But I don't think the board refusing to listen to you on that sort of point is an automatic, you must step away from a regulatory perspective. From your personal perspective, that may be different.
Yeah, I think that's right. As I say, the academic commentary that I referred to is often to give, sometimes in-house solicitors have to walk away. They have to say, I don't know how often it happens, but they have to say, I either follow my advice or my ethical obligation is so compromised, I'm going to have to leave. That's obviously underpins some of the academic research that's a kind of nuclear option. But so I think that's right. I think we would approach it much more around, can you give your proper advice and keep your independence, rather than being told per se that the entity that we don't regulate it might be facing financial difficulties. I hope that's a rather long-winded way of getting where.
Well, so you also have to bear in mind the role. Sorry, we could go on for a while on this because it is an interesting one in terms of if you're general counsel, you may well be a director of the company as well, which means obviously there are potentially personal liability issues at that point, I think, for wrongful trading. So obviously there's that context as well, which is separate to our regulatory reach. But again, like Gareth said, on the academic side, this is why it's an interesting area in terms of should general counsel, etc., holding executive positions, for example, and where these can cause issues for the individual.
Thank you. Another interesting question, which I think probably is something that our in-house colleagues are getting more and more involved in. Somebody has asked the question about in-house solicitors working for other organisations. So, for example, a charity that's been set up and is supported by the company, and I'm assuming by that question they may well mean their employer company. And is there any guidance that is particularly relevant to that type of scenario?
I think this relates somewhat to the section 15 point again around section of the public, and the extent to which organisation would need to be authorised to do the work. So yeah, I suppose it'd be worth us circulating that guidance at the end because it deals with it. And I think, Carol, there's also some guidance on the pro bono aspect of that as well, isn't there? Which is, of course, it's complex in itself, because if the organisation isn't regulated and then you're providing reserved advice to external individuals on a pro bono basis, it can cause some complications as well.
Okay.
Yeah, I think we do have, I can't now recall some guidance on this issue because we want to encourage, obviously, solicitors who want to act in this way and help charities, you know, to do very valuable work, to be able to facilitate that and not make sure our rules don't stand in the way. Whereas the legislative matter, we've obviously got much less discretion. But I think Stephen is right. I think it is referenced in the pro bono guidance that we've been developing with Law Works, and so I think we should circulate that link around as well.
Excellent, thank you. I think we've got time probably for just a couple more. An interesting question: would the SRA regulations override confidentiality obligations in employment contracts? An example being given is if somebody wanted to forward records onto their personal emails.
So someone wants to, I'm not quite sure I understand the question. So, so our obligations of confidentiality are to keep clients' matters confidential.
Yeah.
And obviously it's the bedrock of ethical practice. So I suppose it's understanding the context in which you would have something in an employment contract that might, you know, if you had an employment contract that said you can disclose confidential information, clearly that would be a breach of the law, a breach of our regulations. So I suspect there's something a bit more subtle that they're getting to there, but which I perhaps you can, whether it's evident from the question, Jane, or if that's something that needs to be fleshed out and we can deal with that subsequently.
Yeah, I think that's right. I mean, you know, just thinking from sort of our own Mills and Reeve perspective, we cannot forward anything onto our personal emails. Some people might think, well, it's much easier to print at home, for example, because that compromises the security of that information is one sort of absolute embargo for us in our practice, and I would expect lots of law firms have similar rules.
Yeah. And we haven't talked about COVID, but we have got Q&As on COVID, and that deals, I think, to a degree with some of the pressures that we're facing with working from home, working remotely, keeping issues confidential. And I think you're right, best practice is you're using encrypted devices to make sure that client information is secure.
Yeah, okay. Another question, do we or our clients, so I think that's the employer organisation, have to publish legal fees where the customer pays for the legal fees? So maybe the customer pays the transaction fees, for example, of the, this might be, I don't know, but this, for example, could be a bank and where the borrower pays the legal fees.
No, I think my understanding at the moment is that our requirements to publish information only relates to law firms and those limited examples I gave. Whether or not those requirements for price transparency might be expanded in due course, I think we're going to see how they bed down. There's been a lot of resistance from law firms to publish information. We're doing a lot of enforcement work and trying to make sure that we nudge people to compliance. So I think we've got sadly, we've got quite a long way before we get to where we get to on that. So I don't think it's going to be imminent. So no, is my feeling is the answer to that.
Okay. I think probably we need to draw this to a close now. I think we've dealt with most of the questions, not all of them. What we will do afterwards is sort of collect, well, I say collect up the questions. I think actually, bearing in mind the anonymity point, if people have a question that they don't feel has been answered or a question that they didn't want to raise in this forum, then perhaps do that through the feedback function. So the next slide, there's a link to our feedback form, and you could raise that, or you could raise it with me individually, and I will liaise with Carol and Stephen to answer that. We've talked a lot also during this session on resources, and indeed some of the questions asked have been around circulating links to resources. So we will also try to do that over the next couple of days for you all. So it just leaves me to say thank you very much to Carol and Stephen. That's been really informative, very interesting. Thank you to everybody who's participated, and please, please, please provide feedback, including other topics you'd like us to cover. Look, thank you.